Well, it looks like the ATF was right about bump stocks the first time before they flip-flopped. The Sixth Circuit Court of Appeals has struck down the bump stock ban by the ATF. The three judges ruled overwhelmingly, and some of the things that I'll pull from this are that they say for over a decade the ATF maintained that a bump stock is not a machine gun. Then they flip-flopped, according to this document, but in 2018 the ATF reversed its position by promulgating the rule. Now this portion right here had pretty big ramifications. These two judges that sided here together, a third judge ruled a little bit different, but same thing in favor of the other two judges, but for a different reason. But these two judges point out very specifically that the ATF has a very ambiguous rule out there. And the fact that they have flip-flopped, and they use the words flip-flop to describe the ATF regarding bump stocks, they are stating that the ATF has created a ruling based on ambiguity. They state that the viability of competing interpretations is exemplified not only by the myriad and conflicting judicial opinions on this issue, but also by the ATF's own flip-flop in its position. And because the statute is subject to more than one reasonable interpretation, it is ambiguous. Now, they go on to state that you cannot have a rule that essentially impacts law and has criminal penalties to it if it's ambiguous. In other words, any kind of ambiguity that you have out there is always going to refer back to the defendant. In other words, the government will always lose in this case, not us. So you can't create something that's ambiguous if it has criminal penalties to it. They state, moreover, we feel deep discomfort at allowing an agency to define the very criminal rules it will enforce. Hello, that's what we've been saying all along, right? We've been saying that the ATF is creating a rule that ends up being a law that they get to enforce at their own discretion. You'll remember the Cargo case, and they also cite that, stating bump stocks may well be indistinguishable from automatic weapons for all practical purposes, but it would be dangerous to punish a crime not enumerated in the statute because it is of equal atrocity or of kindred character with those which are enumerated. In other words, it's saying that just because you call a bump stock a machine gun does not make it a machine gun. It may function very, very similar to a machine gun, but the fact that they both function similarly still does not make one the other. They follow that by saying because the relevant statutory scheme does not clearly and unambiguously prohibit bump stocks, we are bound to construe the statute in Hardin's favor. They also mention it's up to Congress, not the ATF, to change the law if bump stocks are to be made illegal. Again, we've been saying this all along. Congress, do your job. They state under this definition, a bump stock cannot be a machine gun part because a bump stock by itself cannot increase the rate of fire of a rifle, nor does it change the mechanics of a single function of the trigger. And they go on to state how the ATF's wording is incorrect and how they use the ATF's own wording against them to say that it is not a single pull of a trigger, that it requires a push-pull action on the rifle itself. They follow that up by saying even if the ATF had adopted its current view from the get-go, meaning bump stocks were bad, that interpretation fits poorly with the statutory text. The ATF substitutes pull for function to argue that there is a single pull from the shooter's perspective, poking holes in the ATF's BS, just like we've been saying. It's almost like they've been reading the registry of all the comments. It's almost like they have read every single one and they're applying our logic to this ruling. Finally, it says, I therefore concur in reversing the district court judgment because the best reading of the statute is that bump stocks are legal. The statutory text confirms that the ATF correctly interpreted the statute the first time. It is the job of Congress, not the ATF, to decide whether the law should change in this area. You know, this is going to have ripple effects. And what I mean by that is obviously what's close on the tip of our tongues right now, the stabilizing brace ruling. In fact, I may be live streaming tomorrow from C-SPAN on some of the stuff that's going on with that, because they're going to be talking to Dettelbach tomorrow and asking him questions about stabilizing brace. I think this ruling right here is going to have some ripple effects in that also, and so many other ways. These types of rulings, along with Bruen, are going to have lasting effects at some point. One thing I do want to point out is that this Sixth Circuit Court of Appeals is a pretty legitimate court. In other words, I see them citing this in a lot of other cases that are not bump stock related, that just have something to do with firearms in general, because this right here completely destroys the ATF.
I'm sorry, I thought this was America. He's